It is worth noting that the President nor Parliament has no power to declare an act unconstitutional. Out of the abundance of caution, I must note that Article 2(1) of the Constitution outlines that any allegation of any unconstitutionality must of necessity be grounded in a course of action before the Supreme Court. The Constitution vests the power to declare an act unconstitutional solely in the Supreme Court. This principle is central to the doctrine of separation of powers and the rule of law. Firstly, it is crucial to understand that if the President believed that Parliament acted ultra vires or beyond its constitutional powers in passing these bills, the constitutionally sanctioned course of action would be to refer the matter to the Supreme Court. The President does not possess the authority to unilaterally declare parliamentary actions unconstitutional based on personal or executive assessments. Such a course of action is not only within the contemplation of our laws, but breaches the established procedure for constitutional adjudication. Honorable members, in the context of our discussion, this means that the bills passed by Parliament are presumed to have been enacted following all due processes and constitutional requirements unless proven otherwise. Honorable members, this procedure underlines a critical aspect of our constitutional democracy. The President cannot outrightly reject a bill in its entirety. The constitutional route provided for dealing with disagreements on a bill requires specific actions focused on collaboration and reconsideration rather than outright dismissal. The approach adopted by the President in this instance, where the bill has been wholly rejected and not returned to Parliament, but retained by the President, is not within the contemplation of our laws as stipulated in Article 106. This procedure adopted by the President, bypassing dialogue and reconsideration, undermines the constitutional process and the legislative authority of Parliament. Honorable members, I have stated clearly that one of the bills, the Criminal Offences Amendment Bill 2023, is already an act. Criminal Offences Amendment Act 2023, Act 1101, after it was assented to by the President on the 3rd of August 2023. So the President can no longer write a letter to say that he is not going to assent to that bill. There is no longer any such bill before the House. It becomes clear that the actions taken by the President in refusing to assent to all the 3 bills do not align with the constitutional principles and procedures that govern our legislative process. This House, as a representative of the people and the custodian of legislative authority, must uphold the sanctity of the Constitution and ensure that its provisions are adhered to in both the letter and the spirit.